Be ready. 5 seconds. Start. It was further urged that the dictum in Coffee Board Bangalore versus Joint Commercial Tax Officer Madras is distinguishable and inapplicable to the fact situation of the present case, and more so may have no bearing after the amendment of 1976 to section 5 by insertion of subsection 3 therein, which opens with non-obstacle clause and provides that the last sale or purchase of any goods preceding the sale or purchase occasioning the export of those goods out of the territory of India shall also be deemed to be in the course of such export if such last sale or purchase took place after and was for the purpose of complying with the agreement or order for or in relation to such export. Emphasis was placed on the objects and reasons of the Amendment Act. In substance, it was urged that the stated sales were in the course of import and could not be subjected to levy of sales tax by the state under the state legislation. Per contra, the respondents would urge that the authorities had considered all aspects of the matter and after due evaluation of the evidence before it justly concluded that the stated sales were neither in the course of import nor export and had taken place on the land mass of the state of West Bengal and thus amenable to sales tax under the 1954 Act and the 1994 Act as the case may be. It was urged that it is an admitted position that the goods were kept in bonded warehouses on the landmass of the state of West Bengal and were sold to the master of a foreign going ship as ship stores threat. It was urged that the expression crossing the customs frontiers of India has already been defined in the CST Act and limits its application to area of a customs station as defined in the Customs Act to mean any customs port, customs airport, or land customs station. In other words, the expression crossing the customs frontiers of India is exhaustive and would not include the bonded warehouses where the stated goods were kept to be sold to the master of a foreign going ship as ship stores. It was urged that being a taxation statute, strict interpretation should be offered to this definition as expounded earlier. It was further urged that the stated sales of goods by no stretch of imagination can qualify the expression in the course of import of goods into the territory of India as is contended by the appellants. For that, the goods must actually be imported into the territory of India, and sale must be a single sale which itself causes the import or is in the progress or process of import. It was urged that the authorities had rightly opined that there was sale within the state of West Bengal, whilst rejecting the claim of the appellant that merely because buyer had no right to consume the goods in question before the ship had crossed the territorial waters of India, that would make no difference because the sale was complete by appropriation of the goods in the bonded warehouse itself. Similarly, the fact that customs duty was not paid on the stated goods would be of no consequence. It was urged that the appellants have for the first time raised a new plea that they had filed declaration. No such plea was taken before the concerned authority, nor any document or evidence was produced in support thereof for the relevant assessment period. The appellants therefore cannot be permitted to pursue this contention. Thus, the appeals be confined to the plea taken before the authorities below that the stated sales were not effected within the territory of the state of West Bengal or in India. The respondents have placed reliance on the decisions in Burma Shell Oil Storage and Distribution Corporation of India versus Commercial Tax Officer and others, Coffee Board and Madras Marine to contend that the issue is answered against the appellants. The appellants have distinguished the decision relied upon by the appellants in Indian Tourist Development Corporation. It was urged that the doctrine of unbroken package evolved by American courts had no application in India as expounded in Father William Fernandez. It was thus urged that the taxable event had occurred on the appropriation of goods at the bonded warehouse itself, which was within the territory of the state of West Bengal. To buttress this submission, reliance was placed on Kiran spinning mills versus collector of customs, wherein it has been held that the taxable event would be the day of crossing of customs barrier and not the date when the goods landed in India or had entered the territorial waters. The respondents would urge that the appeals are devoid of merits and be accordingly dismissed. As noticed from the finding of fact recorded by the authorities. It is not in dispute that after importing the stated goods,